Hi, this is personal injury trial attorney Arkady Frekhtman, and welcome to Comment Counsel. This is the show where we go over your comments and we respond and we talk about your comments and give you feedback. So let's get into it. The first comment that I see is from Lacey, and she asks, curious if you could give me some information on a doctor. This is a doctor who did a surgery where they transected the ulnar nerve and also fractured elbow, but they never reported to the patient who was the doctor was trying to hide it in the medical file, did not have informed consent, and also slandered the patient to try to make themselves look better to get out of what they did. Yeah, so I mean, that sounds terrible if that's what really happened. What I would recommend in any type of medical malpractice case, the best thing to do is to get a copy of the complete medical records from this doctor, from the hospital, from the surgery center, from everyone, right? Just do it yourself as the patient. You're entitled to a copy of your medical records. There's a law called hitech, which is a federal law. So something like the most they could charge is, I think, $6, and you're gonna get the whole medical record. Now, once you have it, then what you can do is contact a local medical malpractice trial attorney in your city, right? Somebody local, and have them review it. And when they review it, oftentimes they'll have somebody like either a nurse on their staff or a doctor they have access to, like their own expert. And then that person will also review it alongside the medical malpractice attorney. And then they'll advise you, right, as to the best course of action, whether you have a case, maybe you don't have a case, right? And then what they'll do is, if they take your case, then it's free, meaning they're not going to charge you money. They're going to handle the case. They have this medical expert, and you have a medical malpractice trial attorney. And so, you know, later on, if they recover money for you, let's say they get you $1 million, well then, you know, they're going to take a contingency fee, a percentage, but you still get the lion's share, which is close to, you know, I don't know how it is in other states. In New York, we actually have a sliding scale. So I think it's like 25% of the first 250, then 20, and if you go over $1 million, it actually becomes 10% is the legal fee. So more money goes to the client. But in other states, it might just be a third, which is 33%. But yeah, that's what I would recommend. Now, if you want me to, you know, if you need my consult, you could also text me, which is 347-566-9595. We could jump on a call, discuss it. You know, I could maybe get you access to the best medical malpractice trial attorney in your city, so we could do it that way. Mel Sells asks, what do you think about disc seal procedures with exosomes? Yeah, so I mean, I don't know too much about that, but I do believe that's a new procedure. And what they do is, I think they take fibrin and they put that in order to seal tears in the disc, right? Because you have vertebra, which are the bones, and in between that you have discs. And the discs are a type of soft tissue, kind of like a jelly. And if you have a herniated disc, it just means the disc has exploded, and now the liquid inside the disc, or the jelly, is leaking outside the disc. So what they do with this procedure, the disc seal, is they actually, just like it sounds, they seal the disc, I think with fibrin. And so if it's sealed, it's not going to leak outside the disc. You don't want the jelly leaking outside the disc, just like a jelly donut, right? If you take a jelly donut, you want the jelly inside the donut, you bite it, but you don't want the jelly leaking outside the donut, especially in a disc, because what happens then is you have all these nerves, right, running everywhere. These are the same nerves that allow you to move, and so it's right along the spinal cord. And so they branch out and they go, let's say, for example, from the neck, they travel to the arms, from the lower back, the nerves travel to the legs, and it lets you move, it lets you, but if that disc is exploded and now it's leaking and touching the nerve, it's gonna cause a lot of pain. So that's why they seal the disc, right? So that's a different type of procedure. Now the exosomes, I think what that is meant to do is to regenerate, you know, so that's kind of like a new technology. I don't know if it's completely been, you know, FDA approved, or if it's completely, you know, been, the efficacy of it has been tested, but you know, it's very promising. And if it works, it's better than doing, let's say, a full-blown fusion, because in a fusion, what they do is they take out the disc, they put in an artificial placeholder, they fuse the two vertebrae, which are bones, together, so you kind of lose the disc, and now everything gets fused together, so you lose mobility. It's a major surgery. It's very, very invasive. Here, the good thing about it is that this is much more minimally invasive, which is good. So if it works, I would definitely do it. Now, in terms of results for personal injury cases, I would have to do a verdict search to see if there have been any. I'm not sure because that's kind of, like I said, a cutting edge new procedure. So I'd have to do that to see if there's been any verdicts on that. Here's a question from Penny Lane, and she says, I work in the healthcare field as a CNA and was going to start nursing school as soon as I could afford it. After getting hit while going through a green light from someone who failed to yield, I don't know anymore. This was February of 2025. As I type this, my L5 herniated disc hurts. I've had steroid shots, MRI, chiropractor for a few months, physical therapy. I'm ready to settle, and my lawyer wants my bottom dollar, and I feel so lost. The accident was 100% the other driver's fault, and one of my witnesses was a cop who was already watching that area. 10 bulging discs, 2 herniated, whiplash. I started treatment the same week of the accident, and my brand new car was deemed a total loss. I'm 38 years old and live in Arkansas. Thank you for your educational videos. Oh yeah, so that's actually, an interesting question. There's a lot to unpack there. So number one, I mean, the thing that really jumps out at me, and if you've watched any of my prior videos, is the fact that the lawyer is asking you for a bottom line. That's not good, right? Because the lawyer should know, if they're a real trial lawyer, and they should know value, they should know what these cases are worth in that jurisdiction. So that's kind of a red flag, right? Because you're the injury client. You're not a lawyer. You don't know what these things are worth. It could be worth $1 billion. It could be worth 100,000. A lot of it depends on how much insurance that other car has, right? But the lawyer should be the expert, and they should be your guide and tell you, hey, I think I can get you X. Would you be happy with X? Or if you're not happy with X, if we go to trial, we could get Y, and advise you of all the different options. They shouldn't be asking you for what your bottom line is. That's not really good. The other thing you mentioned that's interesting is that if you're a CNA, right now, but you want to go to nursing school in the future, and now you can't do it, you could sue for that. I mean, I don't know if you have it in Arkansas, but they should, because you definitely have it in New York. I've actually did a case where a guy was hit on a bike and he was a waiter, but he was also planning to go to school. He actually started school to become a financial advisor, right? Like an accountant. And so he still was able to go to accounting school, but it was delayed by 2 or 3 years. And so we showed that, that salary of an accountant is much better than a waiter. He was only a part-time waiter, and it was like $50,000 a year approximately. So the jury actually gave him, I think, about $80,000, close to $100,000 for those 2 years that he missed because his occupation was delayed, right? And there's actually a jury charge in the pattern jury instructions specifically about that. And it's not very hard to prove. You just have to prove that you were planning to do it, that you had real intentions of doing it, and that, your plans can't be completely speculative. You have to have some, concrete plans. Like he was actually in school, so he qualified. It sounds like if you're already working as a CNA, you're in the healthcare field, you're going to start nursing school, you're also would qualify. Even like 16-year-olds who were like planning to do something like ballet or, but they qualified according to the case law I remember reading. So you should be good with that too. And that could be a large lost wages claim, whether you don't go at all or if you just delay. If you delay, obviously you get the money for the delay. If you don't go at all, then it would be even bigger because the lost wages claim would be even bigger. So that's something you could also sue for. But otherwise, it sounds like a pretty standard case. I mean, the other side is at fault. Definitely find out how much insurance they have. It only happened, February of this year, so it's still relatively new. See if the lawyer filed a lawsuit, because if they're trying to settle the case without even filing the lawsuit, they might be lowballing you, because a lot of times these insurance companies have different adjusters. So they have a pre-litigation adjuster, and that pre-litigation adjuster only has authority up to like say 10 or 20,000, right? Or some limited authority. And then once you file a lawsuit, now it goes to court and you get a litigation adjuster and they have authority maybe for the full policy. It could be a 100 policy, it could be a 250 policy, even a million policy. So you want authority for the whole policy, and then you can get a lot more money. So that's always something to, and the difference between pre-litigation versus litigation, for most law firms that know how to go to court, it's nothing, right? It's like you have your case management software, you press a button, it merges the complaint, 15 minutes, you get a lawsuit, you file it, and you're done. And now you get a litigation adjuster, you have access to much more money. So it's not much work for the lawyer, but it's like leaps and bounds for the client. I even had cases where I remember a nice gentleman, he got hit by a truck and they were trying to settle it for like 10 or 15,000 when I filed the lawsuit, even though it went to federal court, which is not the best venue. But anyway, we settled it for like close to $1 million, like 990. So like 10 or 15 before a lawsuit, and then after lawsuit with a little bit of depositions and work, almost $1 million. So that's the kind of drastic difference you could see. So yeah, but yeah, if you need a consultation also, just feel free to text me. It's 347-566-9595. And I'm happy to help. And then JT Flowers responds to my short about construction accident case gone wrong. And he says, this is scary, as I am someone who has experienced life-changing injuries from a construction accident. I wonder if the defense will start using this as a scare tactic to settle cases for less than the value. I don't understand why a judge would do this. Why is the trial judge's incentive to do this? Is it jealousy? Oh, I see. He's talking about how they reduce some of the verdicts in New York. I mean, yeah, basically what they're doing is that they're looking to past cases, right? Like called precedents. So other cases. And they're looking as to this same injury that a person suffered and what has been affirmed as reasonable in the past. Because under the law, you have to get reasonable compensation for that injury. So if a jury does, really sees, hey, this person is really hurt and thinks, okay, I'm going to give him 20 million. Well, the judge will look, well, what's been sustained on appeal in the past for this specific injury? And, it's probably not 20 million. It's probably like 500,000 or 700,000 or maybe 1.5. So the judge could say, okay, take 1.25, something in the range of what's been sustained in the past. Or if you don't like it, then do the trial all over again. And if you don't want to do the trial all over again and you don't like the judge's decision, what you have to do is then file your own appeal and have the appellate division, comment on what's reasonable. But unfortunately, the appellate division is also conservative, at least in New York, so they tend to cut the amounts. Now, in other states, like in California, they don't really cut. Like whatever you get, like there was a verdict of, I think, 23 million, but with interest, because it was like an 8-year-old case. It was actually like 34 million. And it was a mild case. It was like somebody was sitting in a car, a truck hit them. It was just like a coup contra coup, meaning it was like a whiplash injury, but there was a brain injury, there was a fusion. But anyway, they just paid the 34 million. They paid it. In New York, that would never happen. They would appeal. They would get that 34 down to like 2 or 3, maybe pay 2 or 3. So it's just, depending on where you are. So unfortunately, that's just the way that the law works. But yeah, it does seem like very low, especially when you compare it to other states. And then another lawyer, Stasio, injury law, says the defense often uses the threat of appeal and the long delays to try and scare lawyers and their clients into taking less. Good lawyers explain this scare tactic to their clients so they can make an educated decision about taking the money offered. Yeah, that's true. I mean, it's just really depends on what the client wants to do. Of course, you can, go all the way, do the appeal, get more money that way. But sometimes if you have a nice offer, you could think, okay, I did a trial, I got, let's say, 15 million or 20 million in the trial, but it's just a paper judgment, right? I don't actually have the money, but they're offering me 5 million in actual money. Do I want to take the 5 million, or do I want to appeal this? And then who knows, right? I'm going to wait 2 or 3 years on the appeal. And then the result of that appeal may be that I won't get the 20 million, most likely, because that's what they do. They'll cut it to maybe 5 or maybe less. So, it might just make sense to take the 5. So you have to make that educational decision, and it's really on a case-by-case basis. But, that's just the way it is. Hust Link, in response to the video, how to get 3 million on a soft tissue car accident lawsuit, says, weird, I got rear-ended by someone going 75 miles per hour. I was completely stopped. I did chiropractic and therapy for a year and was told to do injections or surgery. I had a minor concussion, soft tissue damage, spine, and a hemorrhage. When I hit my head against the window, I got 14,000. Right, so no, that's not weird. I mean, most people do get something in that range, right? Like 10,000, 20,000, 14,000. It's just, this was like kind of an outlier, this one, where they went to trial. It was a soft tissue case, but the lawyer didn't, settle for less. And I don't know if, I forget, because that was a few years ago I made that video. I forget if they weren't offered much or if they just wanted to go to trial despite a small offer, but they were probably offered something like that, like 20, 30, whatever. But they went to trial and they got 3 million. So that's kind of like an outlier result just to show that it is possible. But yeah, it's definitely not something that happens in every case. Also, you have to have like a real trial warrior who's passionate, who's going to go to trial, who's going to spend the money, right? Because let's say you go to trial on a soft tissue case, you have to call the chiropractor, maybe the physical medicine doctor, the physical therapist. You know, you might have to call 2 or 3 doctors. Each doctor could charge between 5 or 10,000. So you're outlying maybe like 30,000 in costs. And if you lose, if you don't get 3 million, right? If you get like 30,000, well, now you're at zero, right? Because you spent 30,000, you got 30,000. So it's a big risk, but this guy took the risk and it paid off for him. He got 3 million, but it's definitely not something that happens in every case. It's definitely not the norm. And then Lotaro says, and if I tell him I'm going to have surgery when the cervical fusion case is over, would the insurance theoretically have to keep the money from the operation and therapy? Very good video. And he's responding to my Raw Law on October the 6th, where we answered some questions live. So no, they don't keep the money, but you could sue for future medical costs. So for example, if you tell them, hey, you're gonna have a surgery in the future, it's not just you telling them, it's really the doctor has to say with a reasonable degree of medical certainty, this patient is going to need surgery like a fusion in the future, whether it's in 5 years, 10 years. So then what you do is you sue for future medical care and future medical costs. And then the jury could then agree and allow for those costs. So for example, a fusion, you know, a full bone fusion might cost $100,000. So then if the jury allocates $100,000 for future medical costs, you get that money as part of the verdict. So there's different categories of damages. There's like pain and suffering, which in New York includes loss of enjoyment of life, right? So that's more like non-economic. And then they're economic. Economic are like lost salary, like if you can't work, lost salary, lost wages, things like that. Another economic damage is actual medical costs. Like for example, going to get epidural steroid injections, right? Each injection could cost $500. You might need to do injections every 6 months, you know, MRIs, and MRIs like $1,000, $1,500. You might need to do an MRI once a year for like whatever body part, for the neck, for the lower back, things like that. But it adds up over the course of your lifetime. And then if you need a surgery, like a fusion, that's an expensive surgery. That usually costs anywhere from, you know, $50,000 to $100,000 for the entire surgery. Plus, you know, you have to pay anesthesia, you have to pay for the equipment, the surgeon, the hospital. So yeah, altogether it could be $100,000. So if they give you that money, you know, you're going to get it, but you have to show with a reasonable degree of medical certainty that you actually will have the surgery. And that's how it that's how it works. And then Fat DiCaprio says, how long after a deposition is a settlement typically? Driver of an 18-wheeler is at fault, an admitted fault. The company has $2 million in insurance. I had 4 rounds of injections in my back. The deposition was 2 weeks ago. Okay, right. So, I mean, typically you figure if it's an 18-wheeler, they're at fault, you had injections, and you've already had your deposition, right? So I don't know if your lawyer wants to take the deposition of the truck driver or perhaps the representative of the trucking company, like a 30B6 type deposition, a corporate representative. But if they've already admitted fault and it's clear that they're at fault, he might not need that. He could just make a motion for summary judgment. And then, yeah, you can just call them up or send them a settlement opportunity letter, like I've talked about many times, you know, and then put the pressure on them, right? Because it depends on who your lawyer is ultimately, how long it's going to take and whether it settles after deposition. And it depends on their tactics and their strategy and what they're doing. Because if they don't do anything, then, you know, nothing's going to happen. They might just keep delaying and delaying. If they're aggressive and they say, look at my medical records, I had injections, I had surgery, you know, you have 30 days, pay me X, right? Like pay me 500,000. If you don't, that's fine. But when I go to trial, it'll be $1 million. Well, now you're putting them in the corner. They have to either pay you 500,000, call you up and say, let's go to mediation. Okay, 500 is too high, but maybe I'll offer you 350 or whatever, and start talking turkey, you know, or like you just said, you put what you're going to do in the letter. If they don't pay you something reasonable like 500 within the 30 days, then after the deadline expires, you're going to trial with a jury and you're asking for $1 million. And, you know, And some trucks only have 750, right? The small mom and pop owner operators. So what are they going to do if you hit for like $1 million or 1.5 and they only have 750, right? You're going to take their truck, or you're going to argue that the entire policy of the insurance is now open, and whatever you get, the insurance has to pay you because they had an opportunity to settle within the limits, but they chose not to. So they have a duty to protect their insured, who's their policyholder. They have a duty of what's known as good faith and fair dealing to that policyholder. So if they violate that duty to the policyholder because they're trying to save money, or they just don't want to pay, or they want to delay, well, then use that against them, right? So you got to leverage all these things. Like, it's like, you know, you're playing cards basically. You got to play hardball with them, because you know, so it really depends on who's handling the case and how they're preparing all this, because it's not like, you know, every case settles after a deposition. Some cases settle before you even file a lawsuit. Some cases settle during trial. Some cases settle, but generally, yeah, after depositions are done, within the next 6 months to a year, a case should settle. But it really depends on like what's actually happening, you know, with the negotiations. So I would definitely ask your lawyer about that. And then Teal Talk Outdoors is responding to the spinal fusion surgery settlement lawsuit value after a herniated disc video. And he says, I'm 25 and was T-boned by a school bus that ran a red light, which resulted in me needing a fusion between C3 and C4. The policy limit is 5 million, so hoping to get good compensation for my pain and suffering. Yeah, I mean, that sounds like a strong case. I'm sorry that happened to you if you're only 25 and, you know, you got T-boned by this school bus, but you needed this kind of fusion at C3, C4. That's a major surgery. So yeah, I mean, I think if policy is 5 million, I would just go for, you know, as close to the policy as you can get, because being 25, you know, you have, what is it, like over 50 years of future pain and suffering, right? And there's adjacent segment disease. So if you had it at C3, C4, you might need it at C2, C3 in like 15 years, as well as at C4, C5, the adjacent levels. That's known with a reasonable degree of medical certainty that people do need those next level fusions as well, because more pressure is put on those adjacent segments due to the fusion being where it is at C3, C4. So that's, you're adding like 200,000 in medical costs right there, plus of course physical therapies and, you know, prescriptions and MRIs and injections and pain management. And being, you know, 25, just the future medical costs could be 3 million, right? And then what about all the pain and suffering from the past up until now, plus from the future, from now and for the rest of your life? Because people live to be like 83, 84, and you're 25. You're talking about over 50 years, way over, like almost close to 60 years. So that could be a lot of money, because think about 60 years, even if, you know, they give you something low, like living with a fusion is, you know, I mean, living with a fusion it has value, right? Because that's a major injury, and you have that loss of mobility at that one level, plus all the things that you can't do. But if they say, even if they say something like for a year, living with a fusion is, I don't know, 50,000, right? Okay, but you have almost 60 years, so that's like $3 million, right? So just that, it could be more than that. So no, that's a great case. Yeah, if you need any type of consultation or advice, just text me, 347-566-9595. I don't know where it happened, but yeah, that should definitely be very good compensation on a case like that. There's a question from The Machine. He says, this case resembles to one I have and keeps getting worse. I have multiple surgeries, 1 million policy, and my lawyer keeps telling me I won't get more than the policy limits, even if the insurance is held accountable for the verdict since 2019. Is that true, or something is off? To be honest, in New York, it is hard to get more than the policy limits. It's not easy, right? Because you'd have to go to trial, get a verdict that's more than the limits, and then show that the insurance company acted in bad faith, that you gave them a clear opportunity to settle within the limits, and they chose not to. So it's possible theoretically, but in New York, the way that they interpret this open policy and bad faith law is not very favorable to the plaintiff. It's more favorable to the insurance company. They see it some kind of as a contract, you know, and they almost like don't have bad faith law. Now, other places like California, Oregon, Florida, Texas, you know, Washington is very good, like Seattle, that area, very good for bad faith law. So it just depends on where you are. But yeah, New York, bad faith law isn't very good. It's very weak. So it's probably unlikely to get more. But I remember this case, we talked a bunch about this. So, I mean, if you get something even within the million, it would be good, because from what I recall, you had some injuries, but it wasn't anything like horrific. Like there was no fusion. I think it was like with arthroscopic, maybe a percutaneous from what I remember. So for an arthroscopic and a percutaneous, if you get like 750, something like that, that's very good. So even under $1 million would be fine. Kay Ligo says, I asked the lawyer I was interested what happens if we need to go to trial, and he said it won't come to that. Very frustrating that so many are unwilling to. And she's responding to the video, play to win, not to settle. Yeah, I mean, unfortunately, too many lawyers remove the jury trial as a possibility, right? And that results in perpetual lowball settlement offers. And I'll give you an example. It actually even happened to a lawyer that I know. At one point, like that lawyer was going to these mediations and he was doing really well. He'd go to a mediation, like 250, go to another mediation, 1 million, another mediation, 1.2, another mediation, 650. And he was like, you know, just like rolling in these mediations. And then, but you know, because he was doing so many mediations, he wasn't really going to trial, and he didn't really need to go to trial because, you know, he's just going to these mediations, collecting money. But then all of a sudden the mediations dried up. Either the company would go to mediation and offer very little, so it wasn't fair, or they wouldn't even agree to go to mediation. And the reason I think, and a lot of people agree, is because, you know, he didn't have those verdicts. So you have to do both. You have to have some verdicts to then show them, hey, this is what's going to happen if you don't pay me at mediation. That if you don't pay me the right number at mediation, I'm going to go to a jury and the jury's going to give me more, right? And he didn't have anything now for like 5 years or 4 years. And then that's how they research people. They look at all the verdicts, and then if they don't see the verdicts, they stop paying. So yeah, if the lawyer doesn't want to go to court, that's not a good sign. 345 Carrie says, if I have $100,000 in medical bills and it's a big insurance company who hit me, would my amount be at least $100,000 to take home? I had 6 steroid injections and my attorney told me my medical bills are a little over $100K. And she's responding to the video, insurance playing games, don't fold. So yeah, so that's a good question, but like I don't like to use medical bills as a way to calculate pain and suffering. Because remember, medical bills are money that you have to pay to other people, right? Like doctors, nurses, whoever. And this is just their salary, right? What, you know, if you have to get a certain procedure, like you have to go to the hospital because you're hurt, or you have to have an arthroscopic surgery on your knee, or you have to have an injection, this is just money that goes to that healthcare practitioner who's doing the procedure. It's like their salary. So why would your amount of pain and suffering be contingent upon what other people get paid to care for you? It doesn't really make any sense, right? Your amount of pain and suffering really depends on the severity of your injury. So you have to ask yourself, well, why did you go to the hospital? Why did you go to that nurse? Why did you go have that surgery in the first place? Because you were in pain, right? And because this is not something that is going to just go away, but it's permanent, it's lifelong, it's painful, and it's like a lifelong forever injury. So that's what you have to show, and you have to show it through your testimony by explaining, these are the things that I used to do, these are my friends from work. Have these people come in and be like, I knew this person from work, we used to do X, Y, and Z. This is my neighbor, this is my family member, this is my friend, here are my photo albums, here's my photos from my iPhone, whatever you have, right? This was my life. I used to play volleyball, I used to run on the beach. Now I can't, right? I used to pick up my child, throw them in the air, now I can't. What is that worth, right? And have it not just from you, but from people in your life. These community witnesses have it with photos, with videos, and really show that human story. Then it becomes much more powerful, and you can get much more than 100,000. I mean, sure, you can get 100,000 in medical bills. Some people say 3 times the medical bills, right? So that's 300,000. But I don't like to use that. I like to sometimes, you know, leave the medical bills as separate, right? That's more of an economic damage. If they haven't been paid, you can get that reimbursed as an economic damage. Because remember, there's different categories of damages, and you're entitled to all of them. It's not like you're entitled to one category but not the other. But the biggest category is always non-economic, which is the pain and suffering, the human losses. So I say, talk about that, really explain how it affected you, you know, and then you get a big number for that, past and future. And then you could also recover some other categories. And some lawyers, what they even do strategically if their medical bills are not that high, they sometimes waive them and say, I don't want any medical bills, because they don't want that number to be an anchor, because sometimes the jury will hear, oh, they have 30,000 in medical bills, let's give them 90,000, right? Using that same example of 3 times or whatever. But the lawyer doesn't want 90,000. They might be suing for like 9 million. So they just say, forget the 30,000. I waive the medical bills. Let's just make this case about the person, the human story, right? So that's very, very powerful. So that's what I recommend. Okay, I hope this was helpful. And this is great. We're getting a lot of really good comments. And let's do another comment council soon. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Bye-bye.